Hi, everyone. Thank you for joining us over your lunch hour for another WESC webinar. We're so happy to have you here. My name is Ali Ramsey. I am WESC's Communication Coordinator. And once again, thank you for joining us over your lunch hour. Our topic today is the merits of mediation, and it's presented by Marg and Rainey, who I was just speaking to, and they are very passionate about this topic. So they're very much looking forward to sharing this with you. If you have any questions for either of them as we go along, please feel free to put them in the Q&A box at the bottom of there. We also have a chat box, so you can put questions in there as well if you'd like, or just introduce yourself, tell us a little bit about yourself and your business in the chat box there. And as always, this webinar is being recorded and will be available for on-demand viewing by the end of the day tomorrow on our website, wesc.ca. So look out for that. And with that, I'm going to pass it on over.
Good morning, everyone. Thank you so much for taking time out of your busy day to attend this webinar on the merits of mediation. We hope that you enjoy it, and please, we'll have a question and answer period at the end of the session, so please let us know any questions that you have. And Rainey, I'll turn it over to you.
Well, I would like to introduce Marg Romanow. Marg is a qualified mediator, what we call QMed. She has fulfilled all the requirements to be on the minister list for Saskatchewan as a mediator. Marg is also a qualified arbitrator, certified employee benefits designation, and she's a registered nurse. So she's the whole package. Marg lives in Regina. She's divorced with 3 children. She owns Future Focus Mediation and Consulting.
And Rainey, I have the privilege to be working with Rainey on a number of webinars like this. And Rainey is a civil law lawyer who is passionate about resolving disputes in a non-confrontational manner. She teaches mediation. She has extensive experience in conflict resolution. Rainey is a qualified mediator, qualified arbitrator, a parent coordinator. Rainey has fulfilled the requirements to be on the Minister of Justice list as a qualified mediator. And Rainey is married and has 3 sons and lives in Regina. So without further ado, I will share my screen and we'll start the presentation. And essentially what we want to focus on today is to illustrate the merits of mediation. And by doing so, we'll go through the components of mediation to share what mediation is all about. So mediation is a peaceful way to resolve disagreements, and it is an informal setting. So a mediation meeting is typically where the 2 parties who are in dispute or in conflict will meet with the mediator. So typically there's only 3 people there. And mediation allows people to share their views, their opinions in a peaceful, respectful setting. The mediation process is well researched and it's established to encourage discussions. Mediation allows parties who are in conflict to address their issues without going to court, without the traditional adversarial systems. The parties themselves meet to try and resolve what's going on in their best interest. They're not having someone else dictate what they feel is best for them. Our job as mediators, as qualified mediators, is to facilitate that discussion. And we are to ask questions and follow a designated process in mediation to ensure that the parties are able to fully share their views, to get the bigger picture, to find out what's happened in the past, and to go forward in a more positive way. A mediator is a certified, professionally trained individual. So to be a certified mediator or qualified mediator, as we call it, QMed, you have to have taken a number of classes and be accepted by a professional alternate dispute entity across a Canadian entity. And we are trained to follow a recognized process. And this process is to ensure that parties in conflict can openly share their views and come to agreements themselves. The mediator will lead the discussions. The mediator will not take sides. We are neutral. Mediators are neutral. We are not advocates. When parties hire a lawyer, the lawyer represents that one individual. As mediators, we are there to bring the parties together, and we do not take sides. We will not make decisions. And that is a key point about mediation, that the parties involved in mediation have the ability to make their own decisions. As Rainey often says, they are empowered to make their own decisions that best meet their own unique needs. And as qualified mediators, we belong to a national organization where we have to engage in ongoing education and also comply with a code of ethics. The role of the mediator is to allow the parties to talk about their assumptions. What happened in the past? What were they assuming? To clarify, to share those points. What are their expectations? What are their concerns? What are their hopes? And by sharing this information, which perhaps was never shared before, they will come to a better understanding. The mediation process is not adversarial. As mediators, we are trained to ensure that the meetings are respectful, peaceful, and focus on positive communication.
I think we all have heard this win-win, but honestly, for me, mediation really encapsulates what win-win means. I have to talk about myself when I encounter mediation. I worked for many years on the court system, and I was really getting tired of trying to solve everybody else's problems to find out that they were not happy with the result. So, and it didn't matter how much I worked. They were not happy because the truth is I was not understanding what they wanted. I was solving one against the other, and it was always one winner and one loser. In mediation, because the parties are there to solve in their own ways, and the ways that they can solve are endless. There is not a judge or an arbiter or a foreign party deciding for you. And it is you who, with all your knowledge, all your desires, needs, come out and solve the situation the best way you know. So you are the best person to decide how to proceed without conflict in the future. Or if there's going to be a conflict, you know how to solve it. Understanding of the other person's view will help you to better accept and address why the other person has responded the way they have. Because sometimes we think, why did he react so violent? It was not such a big thing. But we don't know what that person heard or understood of what was going on. So the mediation process helps us to really talk to the other person in more a friendlier way, in a peaceful way. So with this better understanding, there is more cooperation, and we understand and realize the reasons and the triggers for the behaviors. And please, if you don't understand something that I mispronunciate, please feel free to ask me, because I'm used to it. You know, this is not my mother tongue, as you can imagine. So through open discussions and sharing our views, you will be able to identify these triggers and avoid future conflict. And if this also, the conflict is something that we encounter every day in our lives. So when we see this future conflict, we will be better equipped to work on those conflicts. Mediation will assist you to work through the turmoil of the past and work towards solutions, agreements, and will create peaceful relationships in the future. The mediation process includes a brief history of the situation. The discussions will then relate to what the needs and the interests are for the future. And I really want to point out to this interest and this needs. I think for many years we have been taught not to think of our needs. But the truth is we should have needs, and those needs should be met. So in the mediation process, we learn that we as humans have them. And we are not hiding them and all of a sudden they explode because we have been tolerating for a long time. But they come out in the way they should. You know, I need this, and the way to have it fulfilled for me is this way. Or maybe I would come up with a different idea. So really, the needs and interests during the mediation process are key. Once those needs and interests are determined, options will be accessed to address those needs in the solution. The role of the mediator is to utilize the steps outlined in the mediation process to encourage, promote, and seek information to generate discussion and understanding. And mediation is voluntary. This illustrates that both people come to the meeting interested in solving and addressing the issues instead of going to court. You know, I have some doubts about this traditional way of solving problems because usually we don't go to court, or I like to think that we don't go to court every day, but we always have conflict. So mediation is more like a human way of dealing with conflict. So you get with a professional that knows how to dig into what was going on, what happened in there at the moment that the conflict explode or it became more visible for everybody. So with mediation, you will be the captain of your own ship. You will decide what to do with the conflict.
And mediation is quite flexible, and it will depend on what the parties want. It can be as fast or slow as you want. And I'll give an example. For instance, in a separation or divorce, one party might be over the relationship and is well on their way to working through divorce and separation or separation. But the other party may not have been in that same frame of mind and are not prepared to move as quickly. So again, it's up to the parties how quickly they want to proceed. The one advantage, though, is that the mediation process does not require waiting for court dates. Again, the parties will determine how fast or how slow, how many mediation meetings they will have. They make those decisions based on their specific needs. And the mediators are available there to assist you and answer questions. If parties are wondering what documents they need, what do they have to prepare, what do they have to seek, the mediator can assist them in that process. And we all have different temperaments and we all deal with emotions differently. So again, even if it's not a divorce or separation issue, if it's even about property lines in a community or a condo dispute, again, people will have that flexibility to proceed as they see fit in the timely manner that they best think will be best for them. And again, if people are well prepared to resolve the dispute or the conflict, then they can gather any information, any documents, and proceed as quickly as they so wish to do. So mediation is cost effective. The hourly rate for a qualified mediator is typically a fraction of a lawyer's hourly rate. It can be a quarter of what a lawyer's hourly rate is. But the key is that mediation brings the parties together. So you can have a quick divorce, but does it really get down to what actually happened in the past? Does it address any communication type of issues so that going forward, the individuals will have a better relationship? And that's most important when children are involved. The parents will have to work with each other for the rest of their lives because of their children. So getting a quick settlement on paper will not address what's been going on with their emotions and some of the things that have happened in the past. So when sometimes people will say, well, why go to a mediator when I could just go to a lawyer and get it done as quick as possible? Mediators are trained in seeking out the information that can best resolve the relationship going forward. The other thing about mediation, it does focus on the future. Obviously, we'll look at some history to understand what's been going on, but the focus will be on the future and the ongoing blame or shame will not be included in the discussions, and that's something the mediator has to take control of. And what are the needs and interests of the individuals going forward? Let's see that those are openly expressed so they can be addressed in the future and better understood by each party to the situation. As part of a qualified mediator, we've been trained on different communication approaches, and we use different tools. And one of the key ones is active listening. So again, the mediator will ensure that both parties are listening clearly.
The mediation process is confidential. And you may think that that is not important, but I think it's a basis for searching for mediation. When you see famous stars and you see this, like their cases in court, and you hear them, oh, they don't want to give the money to their kids, or they mistreated a worker, and you really don't hear the whole story, but you hear all these things and really modify the way you see and you think about these personalities. You really think, wouldn't it be better if they would do this by mediation, if they solve their conflict through mediation? So confidentiality is a key issue for mediation. It means that the discussions in mediation will not be published. They will not be used in any further court proceeding, of course, with some exceptions. It's not like if a crime will be committed or it was committed, we have the duty to say that. But our ethical way of behaving as mediators is we cannot share in court nothing or anything that has been said in the mediation process. All discussions are confidential, and because they cannot be used in the future proceedings, parties find that they are free to brainstorm and share all their possible views and options without concern that these ideas may be mentioned later and affect them. Mediation, in most cases, it's really a very safe place to share your ideas, to feel that you are in a safe space to talk about what happened. So, because they feel safe, people share freely their views, and I really think that that's a priority for going to mediation. And you and even talking about business, you don't want to know the person, some of the people that are buying for you, all the things that you went through with a customer, or that you had problems with a worker. Those things are very well kept when nobody hears but the person who were involved. Sometimes the procedures in court, we really don't know the whole story. So we just hear this side of the things and we make assumptions. Mediation allows us to take that out of the market of the publicity, and we are kept in a safe place. The mediator is not an advocate, and by this I mean a person that publicly supports or recommends a particular cause or policy, but also somebody that decides for you. You don't want somebody to decide for you, because I believe we have the power, we know what we want, we don't need anybody to making the decisions for us. I think we are at this time in society with it has been very challenging for us as women to have the power. We don't want anybody to take it from us and decide, oh, I wanted you to have this, but I didn't want it. So, it is our decision and it is our choice what we want. The mediator is the neutral person trained to make an even feel for everybody to help find their needs and interests. And again, this is important for women, or maybe I'm the only one. Please, if I'm the only one, I really feel happy, but I have felt many times that I'm not on an even field because I'm a woman. I'm many times not on an even field because I have an accent. So a mediator is somebody who tries to even it up and try to balance the parties so that they don't feel weak in front of the other person. And that is a wonderful thing. Mediation then creates better understanding because you don't see the other person as if somebody's patronizing you, or you don't patronize anybody. Better understanding allows people to more readily accept the response of others. Acceptance of other views and understanding creates peace.
Mediation is voluntary. And this is an important component because the parties have to have some willingness to agree to enter into mediation. So they have an openness. They're willing to look at it. They're willing to look at resolutions. So it creates an atmosphere in it for positive futures. And because they have volunteered, there's a sense of commitment there. They've said, okay, we're going to give this a try. And they have that commitment now to go forward and take the time and spend the time to talk about perhaps why things happened in the past, the reactions, the emotions, and going forward to better understand each other. So again, for future, they will be able to understand why people did what they did and either avoid or accept or work through those types of reactions. And the other thing, the people volunteer because they know they will have the power to make their own decisions. Some people will volunteer to go to mediation because they don't want their decision in a court document. They don't want their decision published anywhere. And that's why they volunteer. Other people want to sort it out before they get to a court stage so that they have most of the items or any type of issues addressed before they take it to the next step, before they take it to independent legal counsel to process. So the key is that voluntary nature of mediation allows people to be open to seeking solutions.
So mediation can be used and utilized in everywhere. You know, honestly, I have done mediation with my sons, not me as a mediator, but me as a party, because I want something to be done and I don't understand why it's not being done properly or the way I expected or why they are not doing what I think teenagers should be doing. So I usually ask a mediator friend to come and help us out because I'm not seem to be the one communicating properly. But there are lots of other ways than we need mediation, and it works amazingly. One of them, and please jump in, Mark, if you feel like it, is like customer service. You know, when we find a damaged product, when we have delivery issues, when we don't have payments, or it helps to understand what the other person is doing. And I know those are everyday issues, but that happens. There's also, Mark has done quite a few workplace conflict mediation. So if you can speak about those, Mark, I will really
And
appreciate
I'm sure many people have experienced conflict in the workplace. And so sometimes it does escalate to the point where a mediator is needed to come in to address it. And it might be because there's assumptions about supervisors being overly critical, or an employee is afraid they're going to be terminated, and the relationship has not been well. So to talk about it through mediation, to understand really what's going on and sort of just get to the bottom of what those assumptions were about. Sometimes it's about competition. Sometimes it's about promotion or assignments, and that's causing conflict between employees or employees and their managers. Sometimes there is mistreatment or negative comments made by different individuals in the workplace. Sometimes there are harassment type complaints. So again, mediation is an option that workplaces can use. And that's not to say that if it's a unionized workplace, the grievance procedure and the formal processes in the collective agreement can still be addressed, but mediation can work in tandem with those other processes and to address them in a less formal manner. One of the things that is, we've talked about it already, but family mediation. So for instance, and Rainey, you've done cases on separation and divorce. you have some examples of the details of conflict in those situations.
Well, you know, unfortunately, many times the kids are in the middle, and the parents don't realize that they are hurting the kids in their way of just thinking that they should be winning something, and they are losing the major thing, which is the family. And they are hurting the kids in ways that sometimes are really unforgettable for them, and they can break the family very, very deep. So when you go into mediation in family matters, it's always good to hear what the person is trying to do with this and what is the result, because sometimes we ignore the results of what we're doing. So that happens, you know, in sport teams, any sport. I think some of us who have kids, you know, we know that we want our kids to be the star of the game, but sometimes they cannot be. And sometimes we feel like we judge that we have been mistreated, and we don't know the reason. And maybe the other person doesn't even realize that they are mistreating us. Or they may have done it, or it may have mistreated our kids, and they have hurt our kids. And it's good to have those conversations. And mediation is a process that can be utilized and facilitates this difficult talks between anybody. You know, what about neighbors? You know, I'm sick of my neighbor not leaving his car in front of my driveway, or, you know, or playing the noise too hard, or not inviting me to use his pool, you know, because or things like that. We have some case like that, and it was a long one when Mark is laughing about that. But yeah, that was the whole issue of the fight, if you wanted to call it that way. Or you know, what about smoking? We have every little issue, when it's not consideredly at the time, can steam up and explode. And I think anything about human beings can be resolved with mediation if we have the willingness. So mediation really helps us to resolve those communication gaps. I love to, you know, like, I don't know if you love movies, but I do, and reading, you know, and a lot of the novels are based on these communication gaps. You know, somebody didn't know that the other person wanted that, and all this misunderstanding is what creates the plot of this drama. But the truth is, it's fun to read them, and it's nice to see them on movies, but it's not fun when it happens to you. So those communication gaps are the primary cause of conflict. Mediation conversations promote this open communication. You will be encouraged to share your views, your priorities, your expectations, your assumptions, concerns, and hopes. So it gives you equal voice and gives you the power to you. And I think that's something that we want. Mediation focus on the future, not in the past.
And again, as we said earlier, that mediation allows people to assess their thoughts and their views, their needs and their interests. They share the points, that what they were really feeling, what caused that conflict, and then going forward, how to better understand each other and avoid that conflict. Greater understanding leads to solutions, and solutions that will have greater chance of being successful long term, because it's their solutions. They're the solutions of the parties. And when people's needs aren't met, that's when those negative emotions are exhibited, like anger, annoyance, aversion, pain. And so if we can talk about what are those underlying needs and sort of ask specific critical questions to allow people to open up and share what they're really feeling, then the examples of positive feelings would be that they understand, they're more confident, they're more willing to accept the state of affairs, that going forward that things will have changed, and they may feel more peaceful, that going forward they will understand where that other person was coming from. So lasting agreements, again, mediation allows the time to share the emotions, so that when they come to an agreement and sign papers, it's not just the papers, it's the fact that they understand where each other are coming from, and going forward, it'll be more positive. So as of early dispute resolution has been implemented, the legislation has been implemented in Regina. And the government has recognized the power and the merits of mediation. That, again, mediation allows the parties to go forward with more positive relationships. And based on that, the government has said, as of March 1st in Regina of this past year, or this year, that if parties want to seek a divorce to the courts, they must first try and resolve the separation and divorce process through mediation before they go to court. So we see this as a positive, in that people who are divorcing will try and work things out on their own in a non-adversarial mediation process. They can also use arbitration, or they can use a parent coordinator, but they can use what they call an alternate dispute resolution process first, before they go into the adversarial court system. So again, we are pleased that the government has implemented this legislation. The legislation was passed a couple of years ago. There was a pilot project in Prince Albert, and now it is in Regina. So it's just started, and we see it as a positive move to allow parties to address conflict, so that going forward they can have more positive relationships. And as Rainey mentioned, when it's a divorce and there's children involved, the creation of positive relationships is key, is fundamental, so that children have a better future themselves.
So we have talked about what is a qualified mediator, or QMET, and we belong to an organization which is called ADRIC. It's Alternative Dispute Resolution of Canada. And I just have to tell you that today we got our first joint article published for it. So we're very excited about that. And this is a national association. And because it's national, we are obliged to follow some ethical rules. And not only we have to follow them, but we also have to be trained, and we have to continue with our process of learning every year. We have to follow the code of conduct for mediators. We have regulations and a lot of other professional requirements, because sometimes we hear about this, oh, I am a great mediator, and we think, oh, yeah, I hear this person and I heard this other one, I gave them the solutions. Well, then you are not a mediator. You know, you are just kind of playing the mother feature there. No, a mediator is really somebody who doesn't tell you the solution, but it digs with you to find your own solutions. So we uphold the integrity and fairness of the arbitration and mediation process. We must ensure that the parties involved in an arbitration or mediation are fairly informed and have an adequate understanding of the procedural aspects of the process and of their obligations to pay for service rendered. The ethics involved conducting mediation and arbitration, in a professional manner. We must be impartial, trustworthy, maintain confidentiality, and conduct all proceedings in accordance with applicable laws. So we recommend that you find somebody who belongs to ADRIC, so you know that we have fulfilled these requirements. And we have provided some of our websites on this slide, and also the address for the Alternative Dispute Resolution Institute of Canada. We also, Mark and I belong to the conflict resolution from Saskatchewan, and I myself, I'm a member of Mediation Beyond Borders International. So honestly, it is a privilege to always work with mediators for myself, because I just find that I'm in love with peace. Peace is for me not the lack of conflict, but the way to solve it in a better way so that we can learn from it.
So in summary, the merits of mediation include peaceful discussions in a conflict, non-adversarial. It's a recognized process. Mediation is recognized, as Rainey said, she belongs to international group of mediators around the world. Rainey and I have also taken courses out of Australia and other countries. So it's recognized worldwide. It's creative. It's creative so that the parties will determine what best meets their needs. A judge or another person does not determine the outcome. We are all individuals. We have our unique needs, and mediation allows us to make decisions and come to agreements based on what we think is best for us. It's peaceful. Again, mediators are trained to ensure that conflict is minimized in meetings. We're taught to not allow disrespectful comments or behaviors in mediation, and how to address those if they do happen. Mediation is less costly than the court process. As mentioned before, mediator costs are a fraction of the price of lawyers, but we will deal with the emotional aspects, and that is the key for future positive relationships. Mediation is confidential. So any discussions, any options, any brainstorming that has been discussed in mediation remains confidential and will not be used in other forums unless required by law. Mediation proceeds at its own pace. The parties will determine that. The individuals who know their situations best will assess their needs, assess what's happening in their lives, and proceed with mediation as they best see fit. Most importantly, probably, is that the needs and interests of the individuals will be addressed so that there's better understanding going forward. In many of these examples we've mentioned, the relationships will continue. You have to continue working with that person in the workplace. You have to live next door to your neighbor, or you have the next condo, or you are married with children and you will be involved with that other ex-partner for the rest of your life. So future positive relationships is key. So Rainey and I, as you see, own our own mediation businesses. Please contact us for any additional information. We each offer a free 30-minute free consultation by phone or by Zoom to talk about mediation further and sort of talk about where you see mediation could fit in your life. We thank you for spending your valuable time to learn more about what mediation is, and we are open to any comments or questions. And Rainey, do you have any other points to make? Any follow-up?
You know, Mark, I think why don't we go like a little bit about what is the most common questions that we get when we get a phone call?
I know when I've had calls, people often say, how many sessions will it take to resolve my issue? And basically, as we've mentioned, the pace of mediation depends on the parties and how they wish to proceed. And usually we have an intake session with each party individually, and then we have joint mediation meetings. So usually it's at least 3 is the answer I give. And I don't know, Rainey, what do you usually tell people when they ask you about how many mediation sessions?
Yeah, basically 3, but I also tell them that the result will be more durable than any other thing that they will try. If I can bring up legal cases, like when the decision is rendered by the judicial, usually in many cases, it doesn't follow. And okay, there's a question, but with mediation, basically it lasts longer. So there's a question on the chat, Mark. I don't know if you want to answer it. And
well, or just to follow up on your point, Rainey, that sometimes people say, I want a quick resolution.
Yeah.
I want to sign an agreement right away. But is it going to be lasting? And that's the point we want to ensure that people come away with, that quick agreements may not be long lasting, may not be as successful as when sort of the needs and interests are more deeply reviewed.
Joanne, sorry, is asking, what if the opposing party do not bring the truth or facts up to mediation? And that is a big one. I'm going to tell you what I try. And I caucus with the other party and say, okay, I'm hearing this. Is this how you see it? And sometimes we as mediators are really working as detectives, trying to see then what the other person is saying is the truth. Of course, it doesn't mean that we can be 100% true of what the party sees, because there is this perception, but we try to really dig into that. But again, it is a voluntary process. So if the party doesn't want to freely give the truth or say the truth, there is nothing we can do. I guess there is the say that you can get the person to the water, but you cannot make them drink. You know what the say is. Please I apologize if I'm not being clear on that. But Mark, what about you?
Well, and that is a reality. Sometimes people aren't forthright, but I guess, again, our role as a mediator is to say, you have entered into mediation, you have entered into a process to make more positive future relationships, and that there is an expectation that you will be truthful. Some of that may come down to when documents are produced. So if we're dealing with division of property in a divorce, and I have a truck and I say it's not worth much, again, we will look into that further and look at the legitimacy of that quote. Or when people value their possessions, or when people claim that they have a job that doesn't pay much. Again, we can get documents, we can obtain documents. And by we, I mean the parties will present the documents, and we can have more discussion about what is, and get close as we can to the facts. Sometimes mediation doesn't work. But I think even when it doesn't work, at least there's been some exploration of what's gone on in the past. Sometimes you have people who have personalities that or are entrenched in their views and will not change. But it's still worth trying mediation to try and open up those communication gaps. Another question that I often get when people call with interest in mediation, they'll say, well, what are the costs of mediation? And why get a mediator when I'm going to have to go to a lawyer at some point? Again, mediators, the prices vary, but in general terms, it's at least $120 an hour to $180 an hour for a mediator. Lawyers can be 2 to 3 times that much. So again, it's cost effective, but more importantly, it's the relationships. It's the time that mediators will take in a non-adversarial process to address relationship issues. And Rainey, do you have any other comments on sort of the cost of mediation?
I think if you think not only the cost, but how, you will feel, this is not about the cost money-wise, but how you feel about it. I always felt when I was a party on the mediation, then at least my point of view was heard. And for me, that was very important, because I was not being misinterpreted by somebody else. And I am sorry, I'm a lawyer by trade, so I guess I can talk that way. Sometimes as lawyers, we think that we know the whole truth, and we forget how our client is feeling. So I know that sometimes the clients felt like they didn't get what they wanted. So for me, it's very important in a mediation that the party is the one that is speaking out and the one that is getting the answer they want. And of course, we cannot guarantee a result because, oh my gosh, we would be wizards and we would be very happy to do it, but we cannot. But we try. And I think what is very important is what we are trying to humanize all the conflict and see what is behind it. Because sometimes we forget how these really tiny things that affect us as humans get put aside, and it is just about how to solve something and forget about our needs.
And I think with mediation, and you can tell we're both passionate about mediation, but it's that nonviolent communication that we can stress, and going forward in relationships, whether it be in a condo or a family relationship, or neighbors, how to address ongoing issues. There's always going to be conflict in our lives. So how can we learn about some ways of communication so that it does not result in conflict and causing additional stress to people unnecessarily? So if there's no other questions, I think we've shared the information we want to today. We thank you for your time.
Thank you.
And Ali, I guess we'll turn it over to you.
Perfect. Thank you so much, ladies, for joining us over your lunch hour. And thank you to everybody that tuned into this webinar. Rainey and Marg's info is up on the screen there. So if you want to write that down, you can feel free to send them any questions you have after the fact if anything comes up, as well as we will have this webinar up on our website by the end of the day tomorrow, and you will get an email link with that next week. Sorry, you'll get an email tomorrow, not next week. And we are doing something different for our next webinar. We are doing a live business advisor Q&A on January 11th, where you can ask any of your questions to our business advisors and get real-time answers. So if you haven't done that yet, register online at wesc.ca/events. And thank you again, ladies, for joining us. Have a great rest of your day, everyone.
Thank you very much.